Hi, Ted here with Berkeley Law and Technology Group. I'm one of the partners of our firm. We're an intellectual property boutique firm. So it means we focus on patents, trademarks, copyrights, trade secrets, that sort of stuff. Today, we're going to be talking about trademark foreign filing and what are the considerations there. A lot of clients will come to us that maybe have already had us file a U.S. application for registration, and they are considering trying to protect their brand beyond the United States. So there's a couple different approaches. The first consideration that I would say you need to look at is, where are you planning to sell your product? Are you planning to sell your product in Canada, in Mexico, in the UK? If you have a plan to sell your product there, then it's a good idea to go ahead and protect your brand in those locations. It's very difficult to set a brand in motion, protect it in the United States, and then find out that you can't protect it also in the EU or UK or Canada, and you have to rebrand going into those jurisdictions. So if you know what your brand is and you know that you're heading in that direction, even if you haven't started selling in that jurisdiction, it might be a good idea to go ahead and get protection or initiate the trademark process. Now, we have talked about in some of these videos about searching. We search the U.S. database. We would likewise want to perform a search in the different countries that we're planning to file, so that you make the most of your money and you eliminate or reduce, not eliminate, but you reduce the likelihood that you're going to receive an opposition from a third party. So what do we do if we want to file? If we're thinking about other countries, what's that decision process? Usually, if you're a very small company, you are probably also functioning as your marketing executive. But if you have a marketing team and they have a plan that is tied into your sales program, and your sales program is looking at different countries over the next 3 to 5 years, or maybe 2 to 5 years, then I would look at that projected sales forecast and where you plan to start selling your product, where you're going to be making an investment in a sales team, and I would get trademark registration going in those locations ahead of time. So look at where you're planning to go as a business, figure out where you think you currently have revenues coming in or you plan to have revenues coming in, and then get your brand protected in those locations at a minimum. Now, some countries have a use requirement, other countries don't. Some you can file and you don't have to show use immediately. You might have to show use after a 5-year period, or your mark could be contestable. So there's some factors like that to consider. But for the most part, I like to err on the side of, if I plan to go into a country, if I'm going to be selling my product or service into that country, then I want to get protection in advance, because it's a heck of a lot cheaper to do it in advance than it is to do it or to fight an uphill battle where someone beats you there, files their trademark application ahead of yours. It just makes it a lot more problematic, and it also may require you to rebrand in those jurisdictions. When it comes to filing in different countries, you can claim priority back to your United States application if you file within 6 months of filing your United States application. You can also file through direct to each country, or you can go through the Madrid Protocol. We don't have time in this video to go through that distinction, but I will do a video on that distinction just so you understand what the pluses and minuses are and the advantages of one or the other. That's the consideration for foreign filing. If you have other questions, you can reach us at 503-439-6500. That's 503-439-6500. Or you can email us at info at bltg-ip.com. That's info at bltg-ip.com. Thank you for watching this video, and we'll see you at the next one.